are live.
We're returning Senate Judiciary, we're taking up S-285 and act relating to interrogation, law enforcement interrogation.
Thank you, Senator Sears. For the record, my name is Ben Novogroski from the Office of Legislative Counsel. Before the committee is draft 2.1 of a strike-all amendment to S-285, which is an act relating to law enforcement interrogation policies. This bill, well, similar to the last hearing, is really just a model policy adoption bill at this point. The difference between the last version and this one is the addition of a new section 1, which is the legislative intent section, and then some additional considerations for the model policy to include when it is adopted. Without further ado, I will embark on a walkthrough of the amendment. So you'll see in section 1 listed as legislative intent, law enforcement interrogation policies. It is the intent of the General Assembly to prevent false confessions and wrongful convictions of individuals subject to law enforcement interrogation, to progress towards a total prohibition of the use of deception in all forms of interrogation, and to ultimately improve trust between Vermont's communities and law enforcement. To achieve these objectives, it is the further intent of the General Assembly to create a minimum set of law enforcement interrogation standards that incorporate evidence-based best practices by 1, prohibiting law enforcement's use of threats, physical harm, and deception during interrogations of persons under 20 years of age, and 2, mandating that the Vermont Criminal Justice Council develop, adopt, and enforce a statewide model interrogation policy that applies to all Vermont law enforcement agencies and constables exercising law enforcement authority pursuant to 24 VSA section 1936, and that should be 1936 little a. I will make that change. I apologize. Section 2 is session law mandating the development of the model interrogation policy. So now on or before October 1st, 2024, the Law Enforcement Advisory Board, which is that subcommittee under the Criminal Justice Council, in consultation with the Office of the Attorney General, shall collaborate and create a model interrogation policy that applies to all persons subject to various forms of interrogation, including the following: custodial interrogations.
Ben, just a quick question. Sorry to interrupt you here, but going up further, in consultation with the Office of the AG, I believe the AG is either on or has a designee on the Law Enforcement Advisory Board. So would it be redundant to have in consultation with the AG?
I'm not sure of the exact makeup of the board off the top of my head, but based on the last testimony, there was no mention of changing the AG or not at that point, so that's why it was kept in.
I'm sorry, go ahead.
No, I mean, if you're just a follow-up to Senator Hashim's question, go ahead.
No, it's not.
Okay. So to Senator Hashim's point, the Law Enforcement Advisory Board has a seat at the table at the Criminal Justice Council. So I think it's duplicative and redundant to have them doing this and then taking it to the Criminal Justice Council. It's sort of giving them 2 bites at the apple. Wasn't this originally the Criminal Justice Council developing this policy?
It was decided that the Criminal Justice, so you'll see that this progresses, that the initial step is through the LEAB, and then it goes to the broader council. That was what was decided last time.
I guess I didn't realize that was decided. I'm actually opposed to that. The LEAB already has a seat at the table with the Criminal Justice Council.
Yeah, that was, I do know that there was discussion about that exact point.
I think also, though, by statute, I mean, it says that the board, the LEAB, shall review any matter that affects more than one law enforcement agency. So I feel like it's, yeah, I'm fine. I think it makes sense to have, you know, I mean, the Defender General's office is on the LEAB as well. Do you know if they're on the Criminal Justice Council?
Well, there's I think the Defender General or the LEAB.
We are on the LEAB, we are not on the Criminal Justice
Right. There is a representative from the LEAB on the council, but the LEAB itself has more members included than what is on the council.
Yeah, so that kind of makes me more inclined to make sure we have the LEAB on this. If there is, like you said, there's no defender on the Vermont Criminal Justice Training Council, but there is on the LEAB.
Correct.
Then, yeah, and then I'm still in support of keeping the LEAB in here like this to make sure that we at least have the defender in on the conversation as well.
Well, I would suspect that the member of the LEAB on the Criminal Justice Council would consult with the whole LEAB before they represent them on the Criminal Justice Council. So they're already included by having the Criminal Justice Council do it.
I know that we have a member on the Criminal Justice Council here.
Yeah, so there's some co-occurring members, but it isn't like the LEAB is appointing someone to the council. There's just some people that have kind of dual membership, so there wouldn't necessarily be that check-in on their behalf.
Well, I mean, isn't the role of the member on the Criminal Justice Council to represent the LEAB?
I'm not sure about that. I think the LEAB has a separate purpose than the Criminal Justice Council. What I'm saying is the LEAB doesn't appoint a council member. They have, like DPS and the state's attorneys, we are on the council and also on the LEAB, if that makes sense. So they're there for representing state's attorneys, DPS, et cetera.
If I might. If we want to put this aside and put it into the miscellaneous judiciary bill, we can. So I don't want to lose the bail bill over this. If there's still issues that need to be addressed. So it seems like we're asking who's going to develop the model policy. There's a concern about this language in section 2, that in the first part, or is that where your concern is, Senator?
That is, well, I see it both in section 1 and section 2 that the LEAB is to develop the policy to go to the Criminal Justice Council. I'm also concerned it looks like it limits the policy to only those under 20.
Isn't that what was decided?
I thought that was what, yeah.
It certainly wasn't what I was supportive of.
I'm sorry, what was the question again? I guess I missed it.
Well,
Maybe.
originally the bill was, the targeted deception bill was limited to people, I think as we passed it was 25. I think our direction to Ben was making the model policy for those under 20. Senator Bowski wanted it for everyone, and I don't think we took a vote on that one way or the other. Am I correct?
Yes, I was willing to compromise when it was a ban for under 20, but when we're developing model policy, I think it should be for everyone.
Well, then I don't know that that's the majority of the committee.
I work at the pleasure of the committee.
I understand that. I'm just looking at you because
Yeah.
but
I seem to.
I don't think committee ever took a position on whether it should be over, and that's my fault. Should be everybody or not. So. The original bill that was vetoed by the governor was 25, I believe.
I think it was a ban
22.
for 22 and under, but the model policy was to apply to everyone.
Right, but it didn't get as detailed as this one does now. It was just to create a policy concerning interrogation. I mean, basically, it was just the first 4 subdivisions that you see here.
Okay.
That was the model policy before.
I don't see a problem with having it applied to everyone. I mean, we're talking about the topic of prohibiting the use of threats, physical harm, and deception during interrogations, and developing and adopting a statewide policy for interrogation. Both people under and over 21 get interrogated or interviewed with law enforcement, so.
I mean, would it be beneficial maybe just to go through the whole thing and then?
No, I think the rest of it kind of sits. we'd say you're not eligible for grants if you don't adopt the model policy.
Yeah, I did, but there were new provisions that I added following this.
Okay, well, go ahead.
Yeah, so skipping from A to subsection B on page 2, the model interrogation policy shall prohibit the use of physical harm, threats, and deception during custodial interrogation of persons under 20 years of age. At a minimum, the model interrogation policy shall define deception as the knowing communication of false facts about evidence or unauthorized statements regarding leniency by a law enforcement officer to subject of custodial interrogation. That is the Illinois deception definition that was suggested by Assistant Attorney General Desano at the last hearing. Subdivision 2 at the top of page 3 says that the model interrogation policy shall also address other forms of interrogation involving persons under 20 years of age wherein the use of deception is prohibited. The subsection C states the model interrogation policy shall prohibit any training of law enforcement officer that employs the use of deception, including the Reed technique of investigative interviewing and advanced interrogation techniques. Then subdivision D starts that there's this is sort of the graduated, it goes up the chain, if you will, from the law enforcement advisory. So on or before December 1st, the LAAB shall submit the model interrogation policy to the Joint Legislative Justice Oversight Council and testify before the committee on or before January 1st, 2025. The council, in consultation with AHS, Vermont League of Cities and Towns, and the Vermont Human Rights Commission. I removed the Innocence Project because I've been trying to get in contact with them for the whole session. Nathaniel Erb no longer works there, so I've had zero contact with the Innocence Project this whole session. And it shall update the LAAB's model interrogation policy to establish one cohesive model policy for law enforcement agencies and constables to adopt, follow, and enforce as part of their own interrogation policy. Everything else then remains the same when it comes to grant eligibility. And then the new additions that you see in the model policy development are also then worked into the statutory model policy terms. But I can go through the
So
statute.
the issue right now is for Senator Bowski and others is the limiting it to 20 years of age. Am I correct? I mean, we can withstand the concern about that. So if I could live with going further, if there was a requirement that the LAB look at court decisions, etc., so that it, you know, we've had a number of court decisions in both the United States Supreme Court, other lower courts, and court decisions in Vermont regarding deception. I think the Attorney General in her first comments talked about a Scott case. I think it was Scott. I don't have all my notes, but I think it was Scott, and it had outlined some. So consistent with court decisions. Is that, I mean, I don't know if that's the exact wording or whatever, but they've put some limits, I believe, on interrogation practices. Am I correct in that?
Yes, so the case law, there are limitations on, you know, how deceptive practices can be employed. You know, basically you can't do it to such a point where it overpowers the individual's will.
Right. So I would support Senator Sheehan Bowski if we put in that. Is that clear what I'm asking?
I'm not sure,
Oh,
and it might be me. I forgot to eat breakfast, so I'm a little extra grumpy and extra
Okay.
confusable.
So is the question,
Well, the question is deleting the 20-year-old, so it's applicable to everybody, but it adding in consistent with court case law, I guess, the term.
I would agree with that. I think it should apply to everyone. I'd also support the additional language that you're describing. I suspect that they would look at case law, but you know, just to make it clear, I'm sure it can't hurt.
I could certainly support that.
So some language along the line, so it's, let's say, looking at subdivision 1 on page 1. And then I would incorporate this, throughout, prohibiting law enforcement's use of threats, physical harm, and deception during the interrogation, or during, the interrogation of all persons, consistent with Vermont common law.
Then I would like to see the Innocence Project in here, and I understand that you haven't been able to get a hold of them, but I'm willing to take on the responsibility of finding the new contact and putting them in touch with you or whoever needs to be put in touch with, because I do want them included in this. They have a huge amount of data and statistics.
Rebecca Brown,
Back around.
if you can find her,
Okay,
the Innocence Project.
I'll do it, but I would like to put them back in.
You and I can try to call her.
All right.
Just so it's clear, Senator Sears, okay, I will not support that. We
Okay.
took testimony from the AG's office. We took testimony from Commander Raymond. Deception is a valuable tool. They were concerned about the individuals, 18 to 21-year-olds in college. They all support this. I don't see the reason for not listening to their testimony on this.
So that, if I can respond, I get where you're coming from, but I think the fact that this is going to the LEAB to develop the policy, they're the ones who'll be addressing those specific concerns regarding where deception can or can't be used and what types of deception can or can't be used.
That's
Am
the
I-
reason for the case law, because there was a case, I believe it was Scott, and that outlines the use of targeted deception when certain cases.
We have federal case law on it too.
But
Brady
anyway,
versus Cooper.
Anybody else with a comment on this before we move along?
Just,
Did the ACLU want, you wanted
just
briefly?
chiming in, I would be a little concerned about saying that we're asking the policy to be guided or to conform to case law, because all the case law does, all that Supreme Courts do is set a constitutional floor, not a ceiling. They say, here's the minimum rights that people are allowed to have, and what we're trying to do is give people some rights that are a little bit above that. We don't have to, the Constitution was not written to provide law, it was written to provide a constitutional floor to say, anything that falls below this is unacceptable. And this is just merely
All
acceptable.
right, but this bill isn't ready for prime time, then we'll come back to it in our miscellaneous judiciary if we have to. I can't support it if I don't have some kind of a basis for them to look at it. So that was my spot. So it's 2-2. I don't know if Senator wants to be out, so it needs to be rewritten, I guess.
I'll talk to Eric about it going into the miscellaneous bill, I suppose.
Well, I mean, unless we can come to some agreement there to get it out of here and get it over there, we would. Senator Norris isn't supporting this. I'm not supporting. We're 2-2 without the case law, and Marshall has pointed out that my idea is not as great as I thought it was.
I didn't say that here.
What I thought I was doing was protecting that floor.
Understood.
I wish Senator Baruch were here.
Yeah. Yeah, because I don't want to lose the bail bill here today.
Yeah, I mean,
It still has to go to appropriations, and we need to get it out today.
from my own perspective, I think this is, I'd also like to prioritize the bail bill. and, if this one is not ready, then we need to have further conversation about it.
At the end of the world.
The people who are convicted on false interrogations might feel differently, or false confessions.
How many people has that happened to over the last year?
I don't know.
Well, I didn't say it's dead. It said it's
You know,
waiting for revival.
it can be one of the infamous zombie bills at the end of the session.
Probably go on any house, go on the auto theft bill.
This bill on the auto theft bill?
We could probably throw in a provision about auto theft into the model policy.
Yeah, Jermaine. Sure. We have to be in community. Honest, did the ACLU have a comment? While we're waiting for some review? I guess not.
Well, I don't know if they can get in without Ben there to navigate
Oh.
the
Oh,
system,
that-
so they may well.
It may, yeah. Oh, there, yes,
Do you
hi.
want me to go try to unmute Indy?
Hello.
I bet I can figure it out.
Oh,
She's all
Oh,
set.
she did it. They
Oh,
did it.
is it?
They
I hope
did
it's
it.
unmuted. Yes,
You
awesome.
are.
Yeah, just for the record, this is Indy Schoenhair. My pronouns are they, them. I'm the policy advocate at the ACLU of Vermont. And our position has been and continues to be that this policy should apply to everyone. And we truly believe that this bill should just move forward. We've had ample conversations around this bill and the importance of it moving forward so that we can end the use of deception and coercion in our state. And so we would really like to see this bill move forward. We think this current draft as is a good improvement above the status quo. And so we would like to see it move forward and hope that the committee will pass it out. And that's all the comments I have.
Thank you. All right, so Senator Baruch is not available.
I was not able to find him.
Not able to find him. So let's hold off on this one and turn to bail. If we have time, hopefully today. Hopefully bail will go quicker than that. What bill? Oh, you're handing that out.
Yes.
Okay.
This is draft 3.1 on top.
So we're looking at draft 3.1 of S-195, which is really an accolating to bail. And the committee has taken an approach that is different from what was introduced in 195 and the other bill, and I can't remember the number of it.
Well, the evidential,
287.
287, yes.
Yeah, and 307, and has chosen to try to hold people accountable through supervision in the community, and when that supervision fails, there will be presumption that they may end up being incarcerated, but that the supervision is key to, in most states, people that are on detention who might otherwise get in trouble should be on some form of supervision. Massachusetts uses the probation department's attached to the court, not the Department of Corrections. So that people are supervised who are on detention. So, we've been through this bill many times, but are there any changes in this draft then that we should be aware of?
I just added the proposed language that was in the separate document, from yesterday to, the electronic monitoring portion. Forgot to remove some highlights.
Well, that's all right.
But, you'll see that in, bear with me one moment, I apologize. 16. Did not. Just bear with me one moment, I apologize. I must have sent the wrong version of the bill.
Huh?
I think I may have sent the wrong draft of the bill. Yes, oh, indeed.
Yeah, cause
Yeah,
you still have all the yellow highlights
Yeah.
from yesterday.
So if you give me 5 minutes.
You got 5 minutes.
All right, thank you.
Would you like to break down the 5 minutes?
Is there anybody, while we've taken the 5 minutes, is there any comments on this bill from anyone in the room? No. Anybody on Zoom would like to comment? I will merely. I think, I did get an email from the governor's legal counsel thanking us for our work on both these bills, last 58 in this bill. She feels that while we took a different approach in 195 to holding people accountable, that she's supportive of that. Did we find this on our iPads?
I can send it or I could share my screen.
Why don't you share the screen would be quicker. If you can do that with Ben out of the room.
That I'm not sure I can do. Maybe in the meantime.
Oh, we have a talented technical expert. Oh, here's
Oh,
Ben.
are you in the Zoom?
And you found Senator Baloo?
I am not in the Zoom.
Oh, okay, well then I can't touch it, but then.
I will do that right now.
We're trying to get, instead of having a hard copy, we'll try the screen sharing copy of the changes that have been made to the bail bills.
Okay.
Pretty much the same as yesterday with the addition we discussed on a single page. So go ahead, Ben.
Ben, just whenever you get me the,
Getting it right now. You should have just gone to the link.
And we put off the reception bill because we're having a little discussion.
Okay.
It's not as unanimous as we'd hoped. However, I've said that we could always do that on a different bill, a House bill, if necessary.
Did you receive the,
yeah, I'm logging on now.
got it.
Appreciate everybody's patience.
This would be draft, what, 4.1?
I'm just gonna say 3.2.
3.2.
And you are co-host, you should be able to share.
Great, thank you. All right, so if we scroll down to the electronic monitoring program. Not to make everybody dizzy as I scroll. We'll see here the addition of subsection E, which remains the same substantively as yesterday. But now for violations of conditions of the electronic monitoring program, the DOC may report a violation of the defendant's electronic monitoring conditions to the prosecutor and the defendant, provided that a defendant's failure to comply with any condition of the program for any reason for a reason other than fault on part of the defendant shall not be reportable. To address a reported violation, the prosecutor may initiate a review of conditions under the bail statute, a violations of conditions proceeding pursuant to the new mechanism in this bill, and I'm going to make this a separate subdivision, or a prosecution for contempt under 7559, or a bail revocation hearing pursuant to 7575 of this title. So substantively the same as yesterday, now just incorporated into the bill itself.
Are there any other changes?
No.
So is there any discussion of the bill?
Yeah, thank you. I think, I'm glad that we, made an approach that I think focuses heavily on conditions of release. And so, we've had a Supreme Court justice refer to our conditions of release as a paper tiger. And I think that with the changes that we're making, there's going to be more supervision, there's going to be more accountability, and it's not just an immediate go to jail situation. I think this is a more nuanced approach. The concern that I do hold is actually on the second page regarding the $200 limit being changed again. I think that there are pros and cons to it, but I think it's a small solution that is why I don't quite consider it a solution, but it's a small change that doesn't get to the heart of the issue, which is the bail system in general. The concerns that I've heard from constituents have to do with repeat offenses and violations of conditions of release. I don't often hear folks being concerned that, people are flight risks or that they're not appearing in court. And so, just to summarize, I think that it's a change that doesn't get to the heart of the issue, but the rest of the bill I support. And I do hope that the 200, that piece changes in future conversations this session. And I'm a yes.
Senator Bosch.
I have additional concerns with the bill, but a significant concern, as I'm sure you're aware, is any change to how we use cash bail, given that I don't think we should be using cash bail at all. And I think if that piece were to come out, I could support this bill with the hope that the changes in the House moved it in a direction that I was a bit more comfortable with. But with that in there, I can't support the bill.
Well, I can only say that actually I have heard from a lot of people. Well, we had an odd case in Bennington, the guy with the airplane. He was a flight risk because he flew over, he was stalking a woman in New York State, fly down low into her, and then come back to Bennington and land his plane. So, I do hear about flight risk. Maybe because of that odd situation. But what I've heard from my constituents, basically the revolving door, catch and release. And it's been consistent throughout. And what we did, instead of saying, You remember the bill originally, one of the bills originally had a 30-day, 60-day, and an indefinite jail period. And what we did is said, let's take a look at what the problem is, and I think we determined that the problem is the repeat violations of conditions of release and the new crimes. And so what we did was suggest that there are ways to hold people accountable that may or may not include incarceration, but would include some form of supervision. And I think that's what's the positive of this bill, is that you have now choices of pretrial supervision, you have choices of home detention, and you have the choice of electronic monitoring, even though I wanted it to be 24/7. It's just not realistic right now, so we went back to passive yesterday. But I think given those alternatives, this is an overall improvement on what was introduced, and I think it helps to address some of the problems that we've seen. So I'm really actually proud of the committee's work on this bill. I certainly accept that not everybody agrees with everything in every bill, and I actually don't agree with everything in all of the bills either. But I'm strongly in support of this bill. I think it will help alleviate the situation that so many of our constituents have been frustrated with. And, I must say that it's like anything else in the criminal justice system. About 95% of the people that are charged in crimes do not violate conditions of release. They do not do anything wrong, but that small percentage is like the squeaky wheel that gets all the attention. And then we have the guy with 45 cases in Bennington, for example. There's other examples around the states. This hopefully will help. Is there any other discussion from anybody in the room? Any other committee members?
I'll just say, I agree with you. I think, probably like everybody else, I've had lots of complaints from merchants in my area about endless retail theft and, their belief that many of these people are already violating conditions of release as they're doing that. And from town officials, same thing, that they're dealing with the same people again and again and again. And we've had a couple of dry holes in this committee where we tried to aggregate retail theft, and we've tried some other things that didn't work. I feel like this one goes right to the heart of that particular piece of the problem and says, if you are that 1% who are persistently violating conditions of release, this in 3 or 4 different ways changes the system to make them accountable. And paper tiger is a good phrase for the way it is now. There just doesn't seem to be a way to meaningfully stop the behavior, and I feel like this manages to do that. So I'm a yes on it.
Then, somebody could please move to Senator Booth.
I move this bill favorably.
Senator Booth has moved version 3.2
As amended. As amended, right?
As amended. That version 3.2 reported favorably as amended. Is there any further discussion? Hearing none, Ben, would you please call? Ben D, please call the roll.
Yes. Senator Brewer.
Yes.
Senator Norris.
Yes.
Senator Malsky.
No,
Senator Hashim.
Yes.
Senator Sears.
Yes.
410.
Okay, I'll report this one to finance. It's got to go to appropriations.
You were saying you wanted to report it.
Thank God. Seriously, just gonna think
You did say thank God.
Yeah, I did say thank God.
looks like we've got a little time to come back to 285.
Now we get time to go back to 285, but I'm gonna You can be the deciding vote, Senator Burke.
And the issue is,
The issue is 20 years old or for everybody. Basically, in terms that, I think the language I suggested that I could support would be, that case law be taken into consideration in the development of the model policies. Marshall pointed out that that was.
I just expressed the concern, I think the way that it was phrased was that, the people who are developing the model policy should, look to case law in the development of the model policy. My concern is that case law, by its very nature, is what courts do, is they set a constitutional floor, not a ceiling. They don't say, here's what you should do, they say, here's the minimum,
what you can't,
the minimum you can do.
yeah, okay.
And so my only concern was that language might sort of cue the
Model policy.
LAAB that's writing
But
the
the-
model policy towards essentially codifying the constitutional floor, which doesn't allow for deceptive behavior. So that.
But the issue was,
Should it
in the
apply to,
bill now, it's 20 years or under
I
for
see,
for the new policy. Senator Bahowski would like, and Senator Hashim would like it to be for everyone, all ages.
I would also like it to be for
Okay.
everyone.
So what I was offering was I could support it if it had that case law. But if it's 3-2, it's fine with me.
So does the case law make it 20 and under?
No, make it for everybody.
So, but, do you, Senator Bahowski and Senator Hashim support adding the case law piece? I'm confused there.
I don't love it, but when it got us to 3-1, I was willing to support it. Marshall's concerns make sense to me, because to me, it sounds like that sort of puts us in the direction of sort of supporting the status quo. So that's where we got into we're at 2-2.
I see.
And I must say, I shouldn't have expressed my concern, so strongly that it came off as if I was saying, don't pass the bill because of that particular language. I was just concerned about how that language would affect the drafters of the policy, and I think there's certainly ways to write that language, because I do think it's important for the drafters of the policy to know and understand the case law when they're writing the policy. It's also important, though, for them to understand the legislative intent is to go above and beyond what that case law, before that case law says.
So is there language currently written that expresses the case?
That needs to write it.
So we would be passing it out with an eye toward amending on the floor?
I'm doing it right now.
Okay.
Well, he's doing it right now. I mean, I think we could just, if we take a tentative vote now, and we see the language
Yeah, well,
in 5 minutes.
I see.
We can take a vote in 5 minutes.
I could also share the screen.
Yes, share the screen again, please.
Do you still co-host that?
I just need to, I think I am.
Yeah, you are.
So what I'd like to confirm is that the way in which this is written now and would be adopted, if it addresses the concerns that were raised by folks like Matt Raymond, and do you remember that conversation?
Yeah.
So, yeah, I think I just have some questions about
Well,
how this.
Once we're moving to make it applicable to everyone, all age groups, not just those under 20.
Right.
That's where I wanted the case law to apply.
On that,
All the testimony, I mean, they wanted it at 18. I thought 20 was a reasonable accommodation because we're talking about raising the age to 19. So,
And where I'm coming from is the concerns that were raised by Raymond are concerns that I don't want to disregard in the creation of this, because I think they're important to consider. And my understanding was that with the way this is written, those concerns would be taken into consideration, and in essence, he'd still be able to do his job.
Yeah, on that point, I mean, the short answer is, I believe it does. And the reason.
That it does address those concerns.
Incorporate his concerns. And the reason why I say that is because, so the way that you would read it now, if you look on the screen, that the model interrogation policy shall prohibit the use of physical harm, threats, and deception during custodial interrogations of all persons consistent with Vermont common law. So basically what that's saying is, I mean, what Senator Bielski said earlier is that it is almost a status quo, but what's being said is that you can't prohibit it in the way, or you can prohibit it in the way that Vermont common law prohibits it, and it applies to everybody. But that wouldn't be an outright prohibition on the use of deception for juveniles or those under a specific age, because common law right now permits that.
Well, then speaking for myself, I wouldn't go along with that because it seems to undercut the previous half of the sentence where
it wouldn't be an outright prohibition on the use of it. It would just prohibit it so that,
we would be just saying, we're not changing the
use
law.
what the current law is.
Yeah.
And apply it to all people.
So, let me just ask a question. So if we all agreed with draft 2.1, we'd be limiting it to those 20 or under. And could we pass that?
If we kept it 20 and under?
Yeah.
I could
Without
also,
the common law, without anything else.
The current printed copy.
Current copy.
I would like it to apply to everyone regardless of age. And it seems like what Ben is saying is that according to common law, simply takes us back to where we are currently, which allows it.
Well, it only allows certain forms.
Right. I feel like, in the world post George Floyd in particular, it's impossible for me to square with my own conscience that we would actively allow deception to be used by law enforcement, because the trust deficit is so vast and deep in our country. I feel like the least we could do is say you can't lie to people when you have them in custody.
I respect the committee process.
Yeah.
I suspect the vote will be 3-2. And take out the common law.
So the current.
Just take out all the references to age 20. Take out the reference to common law.
Yeah, so just say prohibiting law enforcement's use of threats, physical harm, and deception during interrogations.
Custodial interrogation.
Custodial interrogations, yeah.
That's the majority of the committee, that's fine. I don't think I'll report the bill though.
I'm happy to. I reported as 6. It seems only fitting.
I was joking.
I know. I just wanted to make sure you knew that someone would.
We were joking about former Senator from Franklin County, Francis Horrigan, who was one time questioned on the floor about a particular bill that he was reporting. And his response was, I didn't fill this wheelbarrow, I'm just pushing it uphill. I think Senator Norris knew Francis.
I did well,
He was a character.
and the family one.
Yeah. So I think we all know the issues, and I know we're running out of time.
Well, I'm happy to move that we report it favorably, knowing that the change is only those ages and we've gone through the rest of the bill.
Yeah.
I know we don't have it like in our hands, but I suspect I can before I have to report it.
Oh, absolutely. Yeah, so.
And I might add, as Secretary has mentioned, that it's probably gonna come out 3-2. And I know we're concerned about lying but in listening to Commander Raymond's concerns, the Attorney General's concerns, and in fact, you had a family member who was a victim of a sexual assault while in college. You may think differently on this, but I don't feel comfortable with this. I would break it down to 18 and under, but I was willing to compromise at 20. But deception is a valuable tool in law enforcement, regardless of what everybody else thinks. But it is what it is. So that's my take on it. I'll be a no on this, obviously.
All right, Senator Bohowski has moved the report favorably as 285 as amended in draft
2.2.
2.2. Is there any further discussion? Please call the roll then. Dahlbach.
Senator Booth,
Yes.
Senator Morse,
No.
Senator Walsky,
Yes,
Senator Shi,
Yes.
Senator Sears,
No.
3-2-0.
Our work is done. And we will take up equal rights on Tuesday. And hopefully there's nobody opposed to giving everybody equal rights.